Are there any other persons, witnesses, parties, lawyers, or anyone else present on this case?
Yes, Your Honor. Elizabeth Vela present. I was appointed court appointee for the safe deposit boxes.
All right, so noted. Welcome to court, Ms. Vela. Any other persons present? Ms. Urbina, are you present on this case?
Oh, yes, I'm present.
And tell the court what your relationship is to this case.
I'm trying to prove that my father is my father. I'm the daughter of Praduma Mumadi.
Your Honor, she's in error, and we have filed a motion for genetic testing pursuant to 204.051A of the Texas States.
I see that. This is your client. Understood. Welcome to court, Ms. Urbina. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is present and also participating by video conference. Are there any other parties, lawyers, witnesses, any other persons present on this case? All right. Counsel, what is the announcement?
Your Honor, I would like to withdraw our motion to withdraw as counsel. When we filed that motion, the case was on an uncontested track, and the amended application by counsel, Ms. Kish, identified our understanding of my client's interest accurately. But now that an intervention has been pled, Sai has asked us to stay on through the determination of heirship.
All right, so you're withdrawing the request to withdraw. Understood. Any objections to any of this by any person? All right, the withdrawal will not be heard. What other announcements are there?
Your Honor, we don't have any objection to Ms. Urbina attempting to prove her heirship. There's, nothing we can. We can put on testimony that no one knows who she is, but she has a right to prove it.
All right, so I guess let me take this step by step then. So the purpose of our hearing today is twofold. One is an agreed motion to withdraw as counsel that has been now withdrawn. The second is a plea intervention for application to declare heirship. This is your filing, Mr. Santos. What would you like the court to know?
Your Honor, we filed the plea intervention about a week ago. There's been no objections to it. Since then, we filed a motion for genetic testing. This is an individual that's pretty much raised my client. And I believe it's been my understanding that it might not even be contested. In the event that this is going to be contested with respect to our heirship, then we would be asking for mandatory genetic testing.
Well, sort of. So there's two requests there. First is the plea intervention. The court has heard that there is no objection, and I think the court even heard that there could be an objection, but just in case, right? Let's put it on the record. Any objections to the plea intervention from any person?
Your Honor, I would like to just ask that I was not served, and the court wasn't even able to serve me notice of this hearing. I learned of it from Sanchander Mumadi's mother. I need to be able to address that and fix whatever reasons I cannot get notice. I also haven't had notice of the, I have the interpleading, but I don't have any notice of a DNA test request.
That's the second point. So let me focus on the first.
Your Honor, the plea intervention is lacking in several areas. It doesn't list Ms. Urbina's date of birth or the other parent. And so my client has no knowledge of Ms. Urbina and is not aware of any parent-child relationship that was formed between his father and Ms. Urbina.
Your Honor, I don't believe there's any special exceptions.
So I'm gonna pause everyone for a second. I'm gonna take one thing at a time. Mr. Flores, I'll rehear whatever argument you have on the plea and then give Mr. Santos a chance to reply to that. But let me take up Ms. Kish's first point. Ms. Kish, it looks like you are right. Tell the court what your email address is.
Karen at Kish, Kisch, lawfirm.com. And it seems that that's in there, but it's not getting to me.
Well, so what the official record says, so the e-service went to the Webb County Court at Law to email address Jenna Innings, Sai Momdi, Gabriela Garcia, Megan Edwards, Jacob Flores, Rudy Santos, Karen Kish, and Cynthia Santos. And for the email address provided to you, it is one of two that shows an error message. Which is odd. And there's no other information provided by the the e-service provider other than there was an error. There was also an error with someone from Mr. Santos's law office. I guess I don't know if that's going to be a reoccurring thing, although I can tell you that the next few filings in the case also show an error for you.
I do have a call into the service to see if there's some reason. I don't know if you know this. If I filed an appearance in the case, would that override it?
I don't know that that's the answer. So there's either one of two things, and none of this, by the way, is legal. I'm just
Yeah, I know.
brainstorming technological roundabout workarounds, I guess. So just for purposes of the record, the email address provided or being used to send information to you and your client is KAREN at KISCHLAWFIRM.com. What I would suggest going forward is several things. Number one, check the spam to see if it's not in there, but I would suspect that it isn't because there's an error message. What I would next suggest is to go in and add at least two more email addresses, another person in your law firm, another lawyer, a paralegal, a legal assistant, legal aid, or something, so that there's at least two others, and file something just to test it out, a proposed order, a fiat, something that isn't, an advisory, just to see if those two new addresses get, because for Mr. Santos, his assistant, I guess, didn't get the first but got the next. So I don't know.
Okay.
All right. So the court shows that there is no actual notice to Ms. Kish. Having said that, Ms. Kish, do you object to the court hearing the plea in intervention?
Hearing the plea? No, Your Honor, we don't object.
All right. So despite there being no proven notice, there's attempted service, but there is no objection to the only person that did not receive it. That being the case, let me now hear, this is your plea in intervention, Mr. Santos.
Your Honor, this is an interested error who's filed a intervention in the lawsuit. It's been timely. It hasn't been tested. There are no objections to it. She has standing. This is an individual that is a biological child of the decedent, and she's trying to establish her heirship in this proceeding. Our understanding is that these brothers were actually aware of my client's existence, but for whatever reason, she was omitted from service in connection with this here.
Response from any person?
Your Honor, my client has told me that he doesn't have any knowledge of Ms. Urbina.
And Mr. Flores, I believe you wanted to say something on the record on this.
Yes, Your Honor. My client as well has advised me that he has no knowledge of having a sister.
Well, nothing I can do with any of this, Mr. Flores and Ms. Kish. What are your respective clients' legal positions as to the plea intervention?
My client has agreed to, if she can prove it via DNA testing, then so be it. But that there's no birth certificate with his father's name on it. There's no other evidence of living as a parent or a child. It's just that she's going to have to prove it from a DNA test.
Mr. Flores? Oh, and go ahead, Mr. Flores.
That we have the same position. There's no date of birth pled in their pleadings. There's no name of the other parent for us to do any research as to whether or not there was a parent-child relationship. We're not opposed to DNA testing. I believe his motion was asking that each party bear the cost of their DNA testing. I would object to the cost being assigned out to my client, and cost sharing could be done after parentage has been determined.
So, if I understand everyone correct, Mr. Santos has filed this plea in intervention. Nobody objects to the actual plea, but they would object to it not being proven and would give the intervener the burden of proving that they in fact are. All right. That is clear on the record. So let's move on then to the request for genetic testing, because that was filed today at 5:33 in the morning. We're not set for that. So let me ask, since Mr. Santos has filed this today, I wasn't even aware of it until the clerk showed it to the court during this hearing. First question, I guess it's going to be a two-part question, first to Ms. Kish and then to Mr. Flores. Number one, do you or your client object to the court hearing it? And two, is there an agreement with regard to testing? Ms. Kish?
Once again, Your Honor, I haven't seen it because I still don't even see it on the docket. But I'm of the same mind as Mr. Flores. I believe if there's going to be testing, that the cost of that needs to be borne by the person that's intervening.
Same questions, Mr. Flores?
Yes, Your Honor. We don't object to the testing, and we don't object to hearing it today, as we'd like this to move forward as quickly as possible. But we do think that the cost needs to be borne by the intervener. If it is determined that she is a child of the decedent, then the cost sharing could be dealt with later by the administrator.
Your Honor, that's not something that we disagree with.
This is something that, I'm sorry, say that again?
That is not something that we disagree with. We're in agreement.
Well, it sounds then by agreement, the court will approve the request for genetic testing and will order that Ms. Urbina be responsible for all of those costs. These are the orders of the court that are due to the court on or before
July 27th by submission.
All right, so it's not a hearing date, just it's an orders due deadline. Obviously, if you file it before, the court will sign off on it before. And there is also a motion to set deadline on August 31st at noon. All right, anything else pending on this case, Ms. Kish?
Not that I'm aware of, Your Honor, no.
Mr. Flores?
No, Your Honor.
Mr. Santos?
I'll please so, Judge.
Well, I do need to set a hearing on the actual declaration of heirship, and that can't happen until after the tests are performed. I tell you what, without knowing anything else, Ms. Rodriguez, give us a final hearing date in September.
September 15th at 2 p.m.
You can probably have an earlier setting if all the results are in and you're ready to go forward. You can request an earlier setting. I just want to set this so far out that you have sufficient time to file this order before July 27th when it's due. File anything you want, amend your pleadings if that requires it or not, and have you all talk and communicate before then. If there is no agreement and there is no other action that is pending, we will come back for final hearing on September the 15th. Between now and then, if there are any changes in circumstances depending on this test, file your request in writing with the court, and the court will set those for hearing as soon as possible. Anything else on this case, Ms. Kish?
No, Your Honor, thank you.
Mr. Santos?
No, Your Honor.
Mr. Flores?
No, Your Honor, thank you.
Ms. Vela, I think for the purposes of your appointment, I believe your services have been fully executed, have they not?
Yes, I had a question. I have an application for my fees prepared for filing. My only concern before that was which party would be responsible for the fees, since I wasn't at the hearing. And I don't believe that the order addresses that. I'm not sure if it's a particular party or the estate in general.
Ms. Vela, and your application, tell the court what your application says and shows. What do you believe are your reasonable and necessary attorney's fees?
So I spent at least 4.6 hours interviewing, going in person to the bank and following up with the bank representatives to confirm whether Mr. Mamadi had any safe deposit boxes at the Bank of America and Wells Fargo locations. After several weeks of following up with them, they were able to confirm that Mr. Mamadi did not have any safe deposit boxes at either location. And I'm requesting a reasonable fee of $900 for my services.
Does any person here have any questions for Ms. Vela or any objection to the court finding that $900 for her services in this case are reasonable and necessary for this community?
No, Your Honor.
All right. Having heard that there are no objections, the court adopts that finding, finds that Ms. Vela has performed at least 4.6 hours of work. The court finds that $900 are reasonable and necessary in this case. The question for the court then becomes whom to assign the fees to. Let me ask you both this, Ms. Kish and Mr. Flores. It seems to me that there is going to be there may be a legal dispute, but I guess in the real world right now, there isn't a dispute as to the two heirs of decedent. And it sounds to the court, unless you all have an agreement or an alternative, that the court should divide those fees equally between your two clients and ostensibly reimbursable by the estate when the heirship is finally declared. Any objection to that, Ms. Kish?
None, Your Honor, we agree.
Mr. Flores?
No, Your Honor.
All right, then each of your clients will pay 1/2 of that $900 fees to Ms. Vela within 14 days. Ms. Vela, prepare that order, send it to the court before July 27th at noon by submission, knowing that the estate will ultimately likely reimburse each of those two persons. Ms. Garcia, anything to add on this case?
Further, Your Honor.
All right. Does any person have any questions? All right. All right. I look forward to calling this case on September the 15th at 2 p.m. I wish all persons well. Have a good day.
Thank you, Your Honor.
A woman walked into court claiming she was the deceased man's daughter. But there was one problem. No one else in the family believed she existed. The inheritance hearing took an unexpected turn when the woman asked the court to recognize her as a legal heir. The existing heirs didn't try to block her from participating. Instead, they made one thing clear. If she truly was the deceased man's biological daughter, she had every right to inherit. But first, she would have to prove it. The solution was simple but life-changing. A court-ordered DNA test. Both sides agreed that science, not speculation, should decide the truth, with the woman covering the testing costs until the results were known. The judge approved the genetic testing and scheduled a final hearing. Now, the future of an entire estate rests on a single DNA report. Because in inheritance court, family stories can be questioned, memories can be challenged, but DNA has the final word. VidIQ.